Possession of a controlled substance. What can you do to beat the charge? Can you avoid a conviction? Today I want to talk to you about exactly that subject. I want to discuss possession of controlled substance charges in Texas. And by the way, I'm Jeff Hampton with the Fulgham Law Firm. Welcome to our YouTube channel. And I want to remind you, if you wait around to the end of our video, I'll also give you a free ebook, What to Do If You've Been Charged with a Drug Crime in Texas. Essentially, it's pretty much the ultimate guide to your drug defense if you're facing a drug charge, okay? So at the end, I'll give you a chance to download that video if you find that helpful. All right, now let's take a look at this for just a moment. First of all, maybe you are facing or charged with a possession of a controlled substance case. Maybe you're in the North Texas area. You want to know what to expect. What are my rights? Is there a way to be able to avoid a conviction? You know, when you think about it, possession of a controlled substance is going to be graded and determined by its severity on whether or not the drugs are seen as more serious drugs like methamphetamine, cocaine, heroin, or whether or not you're talking about certain prescription drugs. Those more serious drugs like methamphetamine, cocaine, and heroin, those are going to be felony charges. Some of your other less serious drugs that you still need a prescription for, you could be looking at a misdemeanor charge. Okay, now you say, well, okay, is it that big of a deal? Absolutely. Number one, your liberty is at risk. Number two, if you do not handle your drug charge the right way, you could end up facing not only jail time, fines up to $10,000, but you could also be looking at something that's going to make it very difficult for you to be able to obtain a job in the future. Look, you don't want people jumping to conclusions and assuming that you're a drug addict or you have other issues just because of an arrest for something that maybe you didn't do anything wrong. Okay, so let's start examining this. Under the Texas Controlled Substances Act, a person commits the offense of possession of a controlled substance if that individual intentionally or knowingly possesses a controlled substance. What's a controlled substance? Well, it's broken down by the state legislature. It can include cocaine, heroin, methamphetamine, GHB, certain prescription drugs, you name it, all the way down the list of controlled substances that each penalty group is categorized by the legislature. They defined the level of seriousness, okay? So if it's a misdemeanor charge, those would start, the lowest level possession of a controlled substance would start as a Class A misdemeanor, punishable by up to 1 year in the county jail and up to a $4,000 fine. If you happen to possess a more serious drug, over 400 grams, you could be facing a first-degree felony, punishable by all the way up to life in prison and up to a $10,000 fine. Now let's talk for a few minutes. What does possess mean? What does it mean when we talk about possession of a controlled substance? Well, under Texas drug possession law, possession means to exercise care, custody, or control over the illegal drugs, and you must have done so with criminal intent. What does that mean? Well, that means you must have done it intentionally or knowingly, something that wasn't a mistake or an accident. Now, when we consider whether someone did exercise care, custody, or control, we need to look at several factors. Number one, were the illegal drugs within your wingspan? Now, what we mean by that is the question is whether the police can determine whether these illegal drugs were within your reach at the time of the search, okay? In other words, when they searched, could you have been able to reach into the area for which they found those drugs? And they call that within your wingspan. That's kind of what the law looks at, is were you able to reach into that area when they located those drugs? Now, the further away you are from the time of the search, the harder it is for that narcotics officer to be able to establish that you exercised any type of care, custody, or control over those drugs. I want you to remember this. Merely being present at the scene where drugs are found by itself is not sufficient to establish that you had criminal intent to exercise care, custody, or control over those drugs. Let me give you an example. A client was riding as a backseat passenger with some friends headed to a club. He hitched a ride with his friends hoping to make it to the club, but instead he was pulled over by the officer, a Fort Worth police officer, for a traffic violation. The driver of the car gave consent to search the vehicle, and drugs were found under the passenger seat. Now, the client was sitting on the back seat behind the driver. So he's sitting behind the driver, away from that passenger seat, okay? All occupants of the vehicle were questioned. No one was admitted to ownership or knowledge of it. What happens here? Now, in this situation, everybody was arrested. Sometimes police will say, well, if someone won't admit to it, then all of you are guilty. I'm going to take every one of you into jail, hoping that they'll have someone admit to it so that not everyone is arrested. Now, I want you to understand, in this situation, those drugs were not within the wingspan of our client. And secondly, they're not able to prove that he had any actual knowledge, any intent whatsoever when it comes to where those drugs were found, okay? How can you exercise care, custody, or control if you couldn't reach it? And plus, they can't prove he intended to. So that's a good example of that, all right? Now, what about the next question is, can the drugs be affirmatively linked to you? So when you're looking at possession of a controlled substance, can the state of Texas affirmatively link those drugs to you? If they can't link them to you, then they do not have a case at a jury trial. Now, what do I mean by that? Sometimes they will find drugs somewhere other than on someone's person or it's something in the, like a wallet or a purse. They have to figure out a way to attach that drug to you, those drugs to you, in order to be able to convict you of that, all right? For example, a group of narcotics agents show up at your apartment with a search warrant looking for illegal drug possession. Maybe you share this apartment with 3 other roommates, and they come in, you know you didn't do anything wrong, so you let them in the door. As they begin to search, they find drugs in a drawer in the living room and immediately begin to question everyone present. Of course, what do you tell them? I have no idea, because they're not yours. You didn't know that they were there. All of your other roommates remain silent too. They're not going to admit to what happened. So the narcotics officer, what does he decide to do? He decides to arrest everyone for felony drug possession because they found drugs. Is this going to hold up in court? Well, if you have a good drug possession attorney, it may be very difficult for the prosecutor to prove beyond a reasonable doubt that you intentionally or knowingly exercised care, custody, or control over that controlled substance when there is no evidence whatsoever affirmatively linking you to that drug. Merely being present won't cut it. Now, it's a different story if they find other things. What if they open that drawer and it turns out in that drawer there's a driver's license of someone? What if there is a utility bill? What if it's found under a book and that book has someone's name on it? What if it's in a particular private room of that residence? It makes it easier for them to establish some type of evidentiary link to a particular person. Okay, but it's important. Your attorney needs to look into this. And by the way, this example illustrates a key point. Do not talk to the police when they question you during a search or execution of a search warrant. If you open your mouth and you start talking to them, they are not going to use it for your benefit. They are only going to use anything you say to use it against you. And what I mean by that is, if they can take information and they can now use that to link you to knowledge or intent, they'll do it. And now you could be facing a drug charge you would not have otherwise had to face. Okay. Now, I'm not going to go over a bunch of these in detail because I've already covered them, but here are possible defenses to a possession of a controlled substance. Number one, no criminal intent to possess. I told you this already. They have to prove that you intentionally or knowingly exercise care, custody, or control. If you're just there, that won't cut it. The number one way that they're able to establish that is either it's on you. With that, I mean, if it's on your person, that's a hard one to argue, right? Or if it's not on your person, they're going to want to ask you questions. So the more you talk, the more they use. The more they use, the more they can rely upon. So very much you need to be aware of that. Criminal intent's either going to come from somebody else or it's going to come from you when it comes to establishing the evidence. One in the next point we have already talked about is defense number two, they're unable to affirmatively link you to the drugs. So once again, if those drugs found somewhere else other than on you cannot be linked to you, they don't have a case, okay? Finally, let me just say this, and there's other ones that we can get into. We can talk about an illegal search and arrest. If you are searched, and the best way to look at this is, let's say someone comes to your house or they execute a search warrant, narcotics officer. First of all, your drug possession attorney needs to take a look at not just the four corners of the warrant itself. They need to look at the search warrant affidavit. That search warrant affidavit is going to provide information about specific facts and evidence that must establish probable cause to search. If that evidence within that affidavit is insufficient, then everything that's seized is not admissible in court. Your drug case could be thrown out. What if the information from that warrant was gathered from a confidential informant that is unreliable? Well, if that confidential informant is unreliable, then everything in it is unreliable. And as a result of that, you have a defective search warrant. So that is another example of a case where you need to make sure you take a look and examine that search warrant if that's what you're looking at, okay? There can also be an illegal drug dog search, the next example. Well, what if they want you to have a drug dog sniff out your car and let me do it this way. The best way to say this is, what if they want you to give consent to search the car and you say no, right? Well, what are they going to do? They're going to bring out a drug dog. And what if you say, okay, well, that's fine, but I'm not going to consent to the search. I'm going to force you to have to bring out that drug dog. And what if it takes them 3 hours, 4 hours? What if you're sitting on the side of the road for an inordinate amount of time? There is Texas as well as United States Supreme Court precedent that establishes if they take an inordinate amount of time and make you wait beyond what is reasonable according to the law, which there's case law that says anything more than about 2 or 3 hours is too long, then that entire stop, the traffic stop and the search, can be thrown out as illegal because the U.S. Supreme Court says they can't just hold you indefinitely. You do still have rights, and if they can't bring a drug dog in time, then they shouldn't be able to just hold you, any citizen who might be innocent, for an inordinate period of time. So you need to look into that. That's an important issue if a drug dog was involved in your case. And then finally, there may be equitable arguments if you were charged with, say, THC oil or possession of edibles, different things where you're looking at oil cases. And what I mean by that is those are still charged as possession of a controlled substance, but many times they're not charged in a fair way. Is it really equitable for someone to be treated under a THC oil or edible case the same way as someone that possesses heroin? I don't think so. Is it fair for someone who has a pan of brownies where 99% of what they have is flour and sugar and 1% of it is oil, but yet they should be charged as if all of it weighed up to a THC oil? That doesn't make sense, okay? But that's the way the law does it. They're allowed to weigh adulterants and dilutants, sugar, flour, all of it, and they get to act like it was all illegal substances. So my point on that, an experienced, good drug possession attorney can really take advantage of those arguments for you if that's what you're facing. And finally, let me just say this. If any of these defenses apply to your situation, your attorney can present, if it is a felony drug possession case, they can present it to a grand jury. And the grand jury, if the weight is off, what if they charged you with possession 1 to 4 grams, but that comes back and that weight is a little subjective in terms of right on the edge, maybe it was right under a gram, you could have the grand jury agree to lower the case to a lesser charge, or if one of these other defenses applies, they could no-bill the case altogether, which means the entire case could be thrown out. But you need to act quick. It's important to make sure that you're working with an attorney that knows these defenses and is ready to do what it takes. And I just want you to know here at the Fulgham Law Firm, we are a team of former prosecutors that have handled these issues in the past. And if you would like a free consultation, have the opportunity to speak to one of our attorneys, if your case is in the North Texas area, don't hesitate to contact the Fulgham Law Firm at 817-877-3030. By the way, I promised you if you waited around to the end of this video, I'd give you a free ebook. Click the link down below. I'll shoot you over that ultimate guide, that what to do if you've been charged with a drug crime book that we have. We'll send it over to you and it'll help answer any other additional questions that you have. And we'd be happy to give you that free consultation if you want to call in. By the way, if you liked what you heard today, like our YouTube video and subscribe to our channel. All right. Thanks again for joining us. Looking forward to meeting you and showing you our next video on our next video series. Thanks again.